phone not operating for me. This is probably same head with some problems.
All right, get started.
Thank you. Good evening. Welcome to the Monday, May 23rd meeting of the Green Bay Plan Commission. What's your pleasure regarding the minutes?
Move to approve.
Second.
Got a motion and a second to approve. All in favor?
Aye.
Opposed? Okay, thank you. And then informational, Plan Commission training.
Thank you, Madam Chair, members of the Commission. So the reason this all came up is because I had spoken to Kevin about conducting quasi-judicial trainings, and since I'm new and there were a couple of people who are new on the Commission, it just seemed like the perfect time to get this done. So thank you for entertaining me coming tonight, actually, and taking over your meeting. So let's go to the first one.
This is still Plan Commission, yes.
Like, I'm not dressed appropriately.
No.
It's just
But you did bring a bottle of something.
I know, right? I thought it was BYOB, right?
It looks like a suspicious bottle, too.
I know, it does look suspicious. It's not. I swear it's not alcoholic.
It is.
Yeah.
We're just going to record it. It's still an open meeting, a public meeting, and also it's just to help us reflect, should we have a new Plan Commission member, just other training things. It's just good for us to have as review. So we noticed this as a regular meeting, just so there's not going to be any action taken, so just good governance, we're going to record it per usual. All right.
Okay.
Great. So the first question is, what is a quasi-judicial hearing? It's such a nebulous term that it definitely requires some explanation. So all it is a hearing that satisfies due process of law. And due process is required any time you have a decision that's going to deprive people of their rights. So if you have, the most common one you hear is the depriving people of life, liberty, or property. In this case, it's usually property rights. We don't usually take people's life or their liberty. It's always the property. So anytime you're taking people's property rights, you have to actually have a reason to do it, or you have to, have a due process hearing to do it. Same thing when you're affecting a small number of people or an individual. So if you're gonna impact one person or a handful of people, they require greater protections than if you're creating legislation that's going to affect the entire community. The reason being that if you don't want to single any single person out without giving them a chance to be heard. And then the last time you would need it is if you were applying factual determinations, or you're making factual determinations about an individual and then applying those facts to an ordinance, which usually is what happens in this case in conditional use permits. You are taking a set of standards that are set out by an ordinance and determining whether the facts support granting it or denying it. Next slide. So when you are conducting a due process hearing, you're acting as a quasi-judicial body, meaning that you're acting basically like a court. You're coming out of that legislative function when you're deciding what's good for the community as a whole and deciding what's actually good for this individual, or I shouldn't say even what's good, deciding whether or not to take this action on an individual. And when you're going to do that, when you're going to act like a court, you have to make those same determinations that a court does. You make determinations as far as facts go, and then you determine how the law actually applies to those factual determinations you've just made. We can go to the next one. So what are the elements of due process? The basic ones are notice in a hearing, and then there's always this nebulous third one, which is you need to make sure that your decision is not arbitrary or unreasonable. So notice actually goes beyond just regular notice. It's actually written notice, meaning that you can't just tell somebody show up today. You actually have to give them notice ahead of time. Let's go over each one individually. So if we go to the next slide, the first one we'll tackle is written notice. Written notice is separate from the notice that you would get from an open meeting. It's actually notice to the person telling them, you have to show up on this date because we're going to discuss your conditional use permit or anything else that would apply. And here is what you should probably consider doing ahead of time, like any instructions that you have, like we're going to limit the amount of time that people can speak, or you're going to have 30 minutes to present your entire argument, and then you have to let them know that they can actually come prepare an entire defense for this, an entire
Case.
Yeah, essentially an entire case, and that they can be represented by an attorney. The next one is the opportunity to be heard. Now, there's two components to that. It has to be done at a meaningful time, and the second one is in a meaningful manner. A meaningful time just means soon enough for it to actually make a difference, meaning that you can't just hold on to it and say, we're going to decide this in 6 months or in a year, or just push it down the line. It has to be something where they can actually benefit from the decision or appeal it so they can move on to that next stage and have a final decision made. Now, written notice, you're never going to really deal with. That's going to be on the staff end. But the opportunity to be heard, the one that's going to be important for you is that meaningful manner. That means a right to hear evidence against the person, refute that evidence, and present their case. We'll go into those more later. The last element is the decision. So when we are actually to the point of reaching a decision, it has to be based solely on the record. And that is all the information that's gathered during the hearing and only during the hearing. You can't conduct independent investigations. You can't have ex parte communications. And when you actually announce your decision, it has to explain why you reached that decision or how you came to that conclusion. And it has to be fair and unbiased, meaning that you actually have had to have thought it out and you've had to base your decisions on facts and law. Next one.
Can I ask a question?
Yeah.
So just in terms of, when you're basing your decision on the record, basically, if the hearing or the testimony is given here in front of the Planning Commission, that whatever is discussed here, whatever is presented here, that's on which commissioners are making their decision.
Yes.
Not like I did something on my own or beforehand, or I know sometimes, checking out the site or seeing what's going on, but really it's about what's presented here.
Yes, and we'll go into that.
Preparation.
We'll go into that a little bit later, but yes, that's exactly what it is. Anything that you guys are going to consider has to be a part of the record. So the first one that leads into this issue of stuff that you come up with in preparation is the next slide. It's ex parte communications, and that's any discussion you have, any statements you receive that are not a part of the record, anything that happens outside of the hearing. And it can be from just one party. If both parties are participating, it's not or everybody who's involved is participating, I should say. It's not considered ex parte because they both have an opportunity to tell you what's going on. But you would want to reserve that for the hearing so you can keep it on the record. Any statements or discussions with witnesses. So if somebody comes up to you and tells you, oh yeah, I'm going to be testifying, and telling you that that's an ex parte communication. And then discussions with members of the community. And that one's hard, especially for people who are elected, because you'll have people come and actually want to tell you their opinion on something. And you're put in this terrible position where you have to be like, look, this is coming before me in a quasi-judicial capacity. I can't hear it yet. That's really that's the hardest one to deal with.
So then probably the appropriate thing would be to suggest that they attend the meeting so that they can have their voice heard.
Correct. Correct.
Is an alternative to that, I know sometimes, all right, somebody might want to talk to you, or maybe they can't come to the meeting. Can they submit a communication or an email to be like read at the meeting?
Yep.
Okay.
Okay, so the next one. The reason ex parte communications are so bad is because they create this assumption that you can be improperly influenced, that you can be inaccurately informed, that you're only provided one side of the issue, that somebody feels cheated no matter what ends up happening, and that you acquire a reputation for being susceptible to improper influence. But the biggest one on there is that if you have an ex parte communication, it can actually invalidate the action you've taken. So that's why ex parte communications are just bad. Now, as far as independent investigations, that qualifies as an ex parte communication because it's evidence that you're getting off the record. But what you would want to do instead is schedule a site visit. The entire commission can actually go out to a site if it needs to. It just is considered an actual open meeting, and anybody else has to be allowed, and you have to get the permission from the owners to be present and all that stuff. But you have a question.
I do.
can see it.
We did go out to see Larson Green at one point, and I wondered if that was considered then an open meeting at that time.
It should be. It should be considered. And what you would want to do is just make it a part of the record. So you would show up, and anything that happens there, you would reserve your discussions until you get back to a place to actually deliberate, and then you would want to have the disclosure of anything you guys saw there made on the record. Make sense?
That was before you came.
Okay. So if you have an ex parte communication, it doesn't mean that all is lost. This whole process is just tainted and there's nothing you can do. So instead, what you need to ask yourself is, have you prejudged the matter, and are you now biased? And if the answer to either one of those is yes, that means you can no longer fairly and impartially participate, and so you have to recuse yourself. That's one of those instances when recusal is necessary. And when you recuse, it means you don't participate at all. So you would no longer sit up here. You can still be in the room. You can still observe, exactly, but you can't sit at the table so that there's an appearance of bias or impartiality or prejudging, and you can't participate in the deliberations. At that point, you could definitely offer testimony if you wanted to. You would just have to be introduced as a witness instead. But your participation is on the commission. When you recuse, it just means you're not part of the commission at that point. So if instead, you can go to the next slide, you do feel like you can still be fair and impartial, you don't have to recuse. Instead, all you do is disclose the communications that you've had and make them, any information that you've received, a part of the record. So, for example, if you get a letter from somebody before the hearing, you'd say, I received a letter from so-and-so, I'm going to make it a part of the record, and then you just put it into the record. And then everybody has the same information, you're good to go. If you go to see a site ahead of time, and this is the other thing too, you guys are chosen for this commission based on your knowledge and expertise, which doesn't mean that you have to have a complete blank slate when you walk in here and you can't have any knowledge of what's going around. It means that you're just supposed to have generalized knowledge. So if you're coming in and you've gone and done an independent investigation looking for these factors, that's not really fair to whoever it is that's coming in front of you. But if you just generally know what's going on, that's not an unreasonable expectation for you to have. It's not a huge community. It would be unrealistic to expect you to have no knowledge of anything before it comes in front of you. Okay.
I'm having real trouble with that one.
Okay.
If I have driven past a place and, that's the one we're going to be talking about, recorded that in my head, is that general or specific knowledge?
That is general. Now, if you're
Okay.
going over there and looking to see what the area looks like, taking note of different features of the building, stuff like that, then that's an independent investigation. But if you just have general knowledge, that's over here, I drive by on my way to work every day, that's totally acceptable and things that you should know.
And is that for anything that's on the agenda or just specific items on the agenda?
Anything that requires a quasi-judicial hearing.
So which items do and which don't?
CUPs.
Well, we know ahead of time.
You will know ahead of time, yes. So the CUPs for sure. I think there's a couple of things, or is it just the CUPs? Because the variances are conducted by the appeals board, and I know zonings aren't, with the exception of.
I mean, this CUP is probably going to be the most common one, just because I think as we talked, like generally the ordinances aren't. I mean,
If we come across something and we know it's going to be quasi-judicial, we're going to give you a heads up. This way
Right.
you know not to
And
primarily
engage in
CUPs.
an ex parte.
I mean, that's what this body deals with, and in terms of most frequency, that's going to be the most important one.
are there times on planning issues that the whole council would act as a quasi-judicial body, or is it particular to the plan commission?
So I'm still trying to figure that out. I'm trying to look through the zoning ordinance to determine what happens after this. Because in theory, whoever it goes to after here is also a quasi-judicial body. It looks like the zoning appeals handles almost everything. The one thing I cannot determine yet is if it should still go to the council for CUPs. So that's the one we're still trying to decide.
And
Okay, yeah.
Tim, you had just asked PUDs.
Yeah, does that include PUDs? Or mainly
PUDs.
just CUPs?
we can talk about this a little more. I just know because it's a zoning, and really you're kind of writing it into as an ordinance. So it's not necessarily.
So there's
Yeah, and we can talk a little bit more because I mean you're limiting more specific properties, but
So zoning has actually, so in New Mexico where I came from, zoning was definitely considered quasi-judicial, but Wisconsin has decided that it's not. And so that kind of creates this little nebulous area where maybe not. And so what we do in those instances is we give a little more due process than we would necessarily. And so like if you have somebody who comes in and you know they're going to be affected, you give them more time to speak. There's nothing ever wrong with giving somebody more due process and just being a little more fair. It doesn't mean that you have to give them the whole process that you are here, but if you just give them a little more due process, you're always going to be on the safer side.
I've been in a couple of planning commission trainings before this and also have a book about planning commission duties and things like that. And in all of those instances, it was a choice whether or not to go to a site and to look at it. There was still the don't talk to people about it, and there was still, you don't go to the site and talk to the person there about it either. But it was always allowed. That was something that was always allowed, regardless of whether it was a CUP or a PUD or.
And that one didn't require you to go as a group?
No, you go on your own.
Huh.
Just to get a better feel for what you're going to, what you're talking about. What the item is.
Yeah, my experience is if it's a site visit and it's something that belongs in a quasi-judicial hearing, it needs to be done as a group so that everybody has the same information.
What about
Yes,
the
sir.
Board of Appeals? Are they affected the same way or involved in the same process? Because they don't really report out, for one thing.
Board of Appeals has the same process. So what happens essentially is that this is the first level. And then there's an appeals process. And I think Board of Appeals is considered that first level. And then whatever comes out of there goes to the circuit court.
I know on some of the bodies where I can recall quasi-judicial hearings, and what comes to mind is Protection and Welfare Committee sometimes, or Police and Fire Commission on some issues. And on those occasions that I can recall, there's been an independent attorney brought in to advise the board. Is that the kind of thing that?
So that
necessary?
is a possibility. It kind of depends on the extent of the determination that's being made. So I have seen some where you do need an independent attorney to advise the board. And it's usually because there's something really complex that the board's, going to be on the hook for, and it's easier to have them have their own counsel. In other instances, if the city attorneys, if their role is not incompatible with what the role of the commission is, then there's no problem with having the attorney advise. In this instance, I usually see city attorneys advising the plan commission just because, we're all technically on the same team. Like, we're trying to do what's best for the city.
When I was on Board of Appeals, we were expected to go to sites. And we had mileage paid to go to sites, to go look at them.
We're going to have to look into that.
okay.
Yeah.
Yeah, they still are. Board of Appeals, they're expected to go and visit the
Yeah.
issue, basically.
So perhaps the issue then is that you're expected to if you're going and conducting an independent investigation, because I think that it does need to be done as a group. But if you go, you need to come back and put on the record what it is that you observed. When you went, when you were there, what you saw.
And to be honest, my biggest issue when I learned about, when I was at the training and they talked about visiting sites, was I wanted to know if we had to go, because I knew on Board of Appeals we were expected to go. And that's where they said, well, you can go, but you don't have to go. So because in the Plan Commission, when we have a meeting here, then the city planners will present everything and show photos, so there's no reason for a person to have to go to the site, is what they were saying. But
Makes sense.
So I'm clarifying as I'm talking.
Yeah,
So-
we're going to look into that because my experience, and I'm going to ask around to see what everybody else's experience is, but generally a site visit is considered an ex parte communication just because you're getting evidence that's not on the record.
I would think the important thing is that when you come to a meeting, you listen to all sides, all opinions, all views, all facts that people may have to present. And, you know, even if you go out and you look at something, you don't make up your mind until you've heard the whole, you know, heard all the facts.
That's got to be a little tough.
Yeah.
Why are you going out there?
And that actually takes us nicely into our next slide. But before we do, you had a question.
Well, I'm just thinking about how I have visited various places, and there is a difference with the CUPs, which often have to do with rental situations. I look at how well up kept up the property is. I am making a judgment there. And I do understand why that would fall under the heading of biasing myself. So I'm going beyond what pictures might be shown here. I would assume if that happened, if I were driving past a place and noticed that, you know, there were always a lot of pieces of junk in the front yard, that I would need to report that then at the hearing,
Yes.
at our meeting.
Yes, definitely. I
Okay.
think that's the best practice. Yeah.
Okay.
I mean, couldn't you just do that if you happen to go by and say like, well, what I noticed when I drove by is this, you know? I mean, then it's putting it in the record.
Yes, and I don't want to create such a burdensome approach that now you feel like anything you've done with the properties has to be disclosed on the record. But if you've made an independent investigation, you've gone to the site, you've seen what it's about, that should be. Now, if you just drive by it on a regular basis, yeah, I mean, I don't see any problem with you disclosing, yes, I drive this on my way to work every day. What I see is this.
Okay, I have another question.
Okay.
So, of course, I forgot what it was already. I'm going to have to think about it, and I will interrupt whatever.
That's okay.
Well, the Board of Appeals also, they ask them if they talk to anybody, which is very
That's
important. Now, there's where you could probably
That's-
develop a predetermined judgment or a bias or
Yeah.
be influenced by it. And I don't think that they require them to, if they do talk to them, I don't know what the consequences are. I don't think anyone ever.
Well, there aren't any consequences per se. It's if you are unable to be fair and impartial, you're expected to recuse.
Okay.
You remembered.
I remembered. No, thank you, Jerry. For Board of Appeals, I know that when I was on the Board of Appeals, what they said was that we had to make our judgments based strictly on facts and law and nothing else. But for Plan Commission, if the neighborhood comes in, and even though it's not facts and it's not law, it's the neighborhood is really upset about a development, we can base our judgment on what the neighborhood wants as well.
So what you're asking about is the type of evidence that can be considered. And we're going to go over that in a little bit. But yes, generally, and I'll explain to you why it is that that's different here.
Okay.
But yes, that's actually true. You had a question before you.
Right.
So-
You know, I think just to follow up on that, I think that when we look at the issues that come here, it's kind of a balancing act, and many of the issues, there are pros and there are cons, and it's kind of a balancing act, which weight do you give the most credibility or importance to? So, it's not a lot. There are very few things, at least in what I've seen here, there are very few things where it's so cut and dry. It's either yes or no. There are opinions on both sides, and you have to weigh them. I think the Plan Commission has done a good job in doing that and discussing the issues and bringing out the facts.
So you said if we just drive past regularly and happen to know something about it, that's one thing. But if we have like a personal history with something, we lived there and we worked there in the past.
Oh, we're going to get to that in a couple of minutes.
We're in
2
office,
slides, I
we're in
promise.
office and it's in our district. So that's different.
Yes, that's
Okay.
different.
Okay.
One more question.
But you have used the word recusal here. when you recuse yourself, do you say anything more than I need to recuse myself, period? And then you move your chair?
I think how you recuse is less important than the fact that you do recuse. So if you just say, I'm no longer able to participate, I think that's sufficient.
All right, I need to recuse myself from this item.
Okay.
Okay.
But you don't provide a reason for the recusal?
Well, once you've recused, there's,
Really no reason to.
yeah, you can't do anything to
We'll turn
change
it
the
back.
proceedings.
I understand.
So,
Yeah.
yeah. I
Okay.
mean, you can. I mean, so if you go to the next one, it's going to be on
We're
conflicts
going
of
to read your whole
interest.
presentation.
That's okay, that's okay. So you all have a duty to disclose conflicts. I know that everybody submits the paperwork at the beginning of the year explaining what interests you have, but when actually something comes in front of you, you have that duty to say, I have a conflict, I need to recuse myself from this. So that's a perfect example. The next slide talks about bias, which you guys have already hit on. And bias can be either actual, like you actually are biased, or if you just have a high risk of bias. So when you get to this whole, you have a personal or professional history with a person or project, that's a bias, or a high risk of bias. If you're advocating on behalf of one party, so if you say, I know that this is a great project, that's taking more of a stance of a witness who's testifying on somebody's behalf than on an independent fact finder who's making that decision as to whether or not it is. And then making questionable comments prior to the hearing. So if you're saying stuff like, I think that this is a terrible idea, or anytime we do conditional uses, it ruins the nature of the neighborhood, and so I think that conditional uses are a bad idea in general, that's also a type of bias. Now, the other important thing to keep in mind is that you can have bias either against a person or against an issue. And it can be bias in favor of a person, it can be against a person, or it can be bias in favor of an issue or against an issue. Now, next slide. Not every opinion rises to the level of bias. You got to make some pretty opinionated statements in order for it to really show bias. But if you have made statements like, I think this is a terrible idea, and somebody says, I think that you might be biased, you should really consider that and think about whether or not you can be fair and impartial, and give everybody their hearing, their day in court, essentially. Do you guys have questions on that?
Just
Yes.
going back to the advocacy, I would assume that this makes for a special issue with somebody who's an alderman and represents a particular district and is likely to have talked about to the applicant or be aware of the pros and cons within the district. Am I right about that? That would be one point where you would move to the audience and then advocate from the testimonial stand?
I think it depends on the nature of your discourse with that person. So if you are having a very, thank you for this information, just getting the temperature of what's going on, I don't think that necessarily rises to the level, but it does make you question whether or not you have bias.
Okay.
Okay. So now let's go to what actually happens at the hearing. So there are some requirements. The first is they have to have an opportunity to present a claim or defense. So if somebody comes in and says, I want a conditional use permit, you have to let them sit down and explain why it is that they think that they're entitled to it. Witnesses should be sworn in and testimony taken under oath. That's not always a requirement, but my advice is always to do it, because if it gets appealed, and we get into discussing what evidence is allowable, one of those issues is credibility. And if you've got people testifying under oath, then it gives more weight to your decision if you've got somebody who's testified under oath versus not under oath.
How do you swear someone in?
So I have an example in here later, but it's just basically do you swear to tell the truth, the whole truth, and nothing but the truth? That's basically it, yeah.
And do you say so help you God, or is that?
Don't say that. Yeah.
Swear
So
on
no
a
Bibles?
court of ordinance.
No Bibles, no Bibles.
No Bible?
Pick the holy book of your choice.
Then that's not real.
And then.
That would be biased.
So the next one is both sides have to.
Right.
Both sides must be examined in order to fairly protect their interests. So you can't just have the person who's asking for the CUP come in. If you've got adjacent landowners coming in and saying, this is going to affect my property, you have to hear both sides. And then the chair presides, but as always, if there's a appeal, it can be overturned by a vote of the commission. Next slide. So as far as hearings go, you can actually establish time limits. So for example, you could say, we're going to give each side 30 minutes to present their case, or we're going to give each speaker 2 minutes to talk. Whatever you want, and you can create some general, everything that appears before us gets an hour total to discuss this. And then, of course, if you've got some really complex issues, you can always modify those as you need. The important part, though, is that if you limit one side, you limit the other side equally. And then you want to swear in the parties and staff, and you can do it at the very beginning. Just have everybody raise their hand and say, I swear, I solemnly swear. I promise I have an example later on. Okay, next one. So the order of presentation, this is assuming the most sophisticated hearings. It's assuming that everybody who could participate is participating. You would have your staff presentation, just giving you the basics, then the appellant or the applicant or whoever coming in and making their presentation, then you would have the opponent, and then you could have the appellant once again do their rebuttal. And then at that point, you can actually take questions or give questions to both sides. So one of the important things is that both sides have to have an opportunity to cross-examine each other, meaning ask questions of each other. And so somebody says, let's say somebody gives some testimony that this, I don't even know, this building is not going to be a problem because it's set back by 30 feet. And somebody said, well, I think it's actually only 28. How do you know? They can ask him, how do you know? All that stuff. The other thing to keep in mind is the chair can actually be the one to ask the questions, meaning that all questions need to either go through the chair, or the chair can actually just have them ask each other directly. Whatever works best for the commission or for the chair in order to keep the proceedings moving along, keep people civil, whatever you need to do to keep decorum. And then staff would close, provide their final remarks, and then the board at that point can start discussions and ask questions of the applicant or anybody essentially who's provided testimony at that point, and then you take your action. Next slide.
Will we get this in written format
We can.
at meetings?
That would help.
Sure.
I seem to recall many years ago, there were some rules of procedure for the Plan Commission. Is there such a thing like that?
Like a little booklet or?
Well, I think it was like a couple of pages of general rules or principles. I don't know. That was a long time ago.
If not, we'll look for them. If we can't find any, we can get you guys some if you need, if that helps.
It would, and to that, it would be really on our agendas, a couple of things. It would be nice to have agendas that people who attend meetings can have when they come in. And the other thing would be to put the guidelines for a meeting at the top of the agendas as well, so that people know, okay, if I want to speak, I sign in. And that doesn't mean that I won't let them speak if they don't sign in, but they'll know that, and they'll know that they can speak one time and those types of things.
So they know ahead of time that their turn's going to come in
Yes.
due process.
Great. Okay. Yes, ma'am.
So what I'm understanding is that we listen silently until everybody has spoken.
So you don't necessarily have to listen silently, but you want to avoid deliberating until you've heard everything.
Okay, so questions to clarify what somebody has said, for instance, would be permitted before that person sat down.
Yes.
Okay.
And if you want to do it intermixed, there's no problem with that. Or if you want to wait till the end, this way you can just see if everybody's going to answer your questions, that's fine too. But the only thing you want to do is avoid actually deliberating, discussing it until you've got all of the
Stating
information.
an opinion, okay.
And that's just at a public hearing, that's not during the general meeting.
Correct.
Oh.
General meeting's totally different. It's just during the quasi-judicial hearings, this is the process to follow.
I thought we were talking about CUPs, and those
Yes.
are regularly done in general meetings.
They are, but it's going to be considered, it's considered its own hearing within the, like anytime it's on the agenda, consider that little piece its own hearing.
Will it be on the agenda again then? For example, when we have a public hearing, we'll have a public hearing about an item, and then it's on the agenda after that.
As an item.
As an action item?
Yes.
So that during that hearing where it's listed, that will be when you're going to
Do the
consider it
quasi.
separately, yes.
And then it'll come up again, and then we discuss it.
And
We'll have a
that,
discussion?
so yeah, you'll close the hearing and then you'll discuss.
Okay.
But we don't usually do that with CUPs.
No.
So how are you normally doing it?
But what I'm wondering is if that's the same process.
Yeah.
The CUP will be the same process.
Normally,
as
the CUP
public
is just like
hearing.
any other action item,
Yeah.
whether it's CUP or PUD or just a simple
Like a zoning.
zone. It's just an action item.
As long as you're giving them an opportunity to have their hearing and you wait until you've gotten all the evidence to discuss it and make a decision, you're going to be fine.
But
That's
we
the
can't
most
ask them
important part.
questions.
Mhm.
But we just don't discuss it. We just ask a question.
Correct.
Well, I think- Well, isn't that how we did like the Venetian Plaza last time? We had the open and so we asked
Yeah.
the questions then, but then when we closed the floor and then we took our discussion amongst
Right.
ourselves at that point.
Yes.
So it's really not a lot different than how we're doing it.
No.
Okay.
Well, at least for that, but
Right.
when we've had CUPs about whether to return something to, whether something that, whether a duplex can remain a duplex when it's been empty for a year, for instance.
Gotcha.
That may be item 5 on the agenda, and it's not a special hearing ahead of time, it's a CUP
Right.
as an action item.
Vanessa, do you think maybe then, in terms of just putting our agenda together, would be good to maybe group those in terms of, I know we have like informational items, but, kind of group those together with like a subheading of like, all right, these are quasi-judicial.
I think that's a good
hearings.
idea.
And just say, so we're all kind of clear then, all right, these ones, we need to follow this process.
Mhm.
Is it ever appropriate for a plan commission to have a closed session on certain things?
So one of the things that we were going to discuss later is when you can close the hearing to deliberate. And it's usually when you have basically two adversarial positions and it's more like a case than a hearing. In that instance, it's possible to close, although before you close, if you're thinking that's going to be a possibility, talk to legal counsel and we can give you advice on whether or not it's something that's closable. But yes, closing a hearing in order, or a meeting in order to deliberate is possible. We just need to make sure the circumstances exist.
What does that mean? Does that mean everyone leaves and we deliberate in private?
Mhm.
Okay.
Yep.
We've never done that.
No.
Not in my 10 years.
No, me neither.
And it will be only if the circumstances exist
Like what?
to justify it. It's, like I said, it's usually when you've got two opposing parties. It's,
There are criteria in
Yeah.
state statutes that apply to
Personnel.
when you can do
budget.
that. I presume the same things that apply to the council apply to a body like this. So,
Yes.
I would think,
yeah.
And that's usually personnel items or budget items
Dollars,
or dollars or
Negotiating
something
a
where you're
real estate.
seeking
negotiating.
Yeah,
legal
negotiating.
advice.
if it looks like something that will, what I'll do is from now on, Kevin and I can confer ahead of time and decide whether or not something is eligible to be closed. This way you guys will know that.
Okay, then yeah, put that statement in there also in our agenda, and that would signify that that's a possibility. That's what we did at city councils.
And then that has to be done, as I recall from state statutes and managing open meetings at the university, that has to be done by vote. That is a roll call vote to move into closed session.
Yes.
And then after that part of the meeting is done, people can come back in and we announce the results of that closed session and whatever
Yep.
language we're
You got it.
advised is
You're-
appropriate.
You're on top of it.
Okay, well, all that time in committees ought to pay off for something.
Okay, so evidence that can be accepted. So this is where the actual elements of what's allowed in the ordinance come into play. And the statement about how we're kind of balancing the different interests, the public versus the individuals. So the reason you can actually do that here, and you can't in other instances, is because the one of the standards for conditional use approval is that the establishment, maintenance, or operation of the conditional use will not be detrimental to or endanger the public health, safety, or general welfare. Because of that, you can take a lot more testimony of a generalized nature, because people can basically say it is affecting my health, it's affecting my welfare, it's affecting my public safety, and so you have an obligation to consider that as part of your deliberations. So any evidence pertaining to that does come in, and a lot of stuff is considered public welfare. So that is exactly where your point about it being, a balancing act. That's where it comes in. So what we would be looking at when you're considering evidence is stuff that is believable, that is relevant, and that tends to prove or disprove something that is one of these factors you're considering. And these are everything from it won't impede the normal and orderly development of the surrounding property, it will not be injurious to the uses of the property in the immediate vicinity, things of that nature. So those are the items that you're actually looking at, and you're looking for evidence that actually applies to any one of these. If it's not relevant to one of these factors, it's beyond what you should be considering. So there are three main types of evidence that you consider. The first is witness testimony, the second is exhibits, and the last is site visits, which are a little more rare. So here is that statement I was promising you about swearing in witnesses. Like I said, it's not required, but it's just good practice, because if you are basing it on whether or not it's credible and you have them saying it under oath, then the credibility goes up because they're saying it under penalty of perjury, essentially. If they come back and they've already testified once, they go sit down and they want to come back and give more testimony, you just need to confirm that they are aware they are still under oath. And that's as simple as saying, yes, you can come give testimony. I want to confirm that you're aware, or are you aware that you're still under oath? And they say yes, then you want to proceed. And then just good practice is keeping a witness list as part of the record. This way you know who it was that actually testified, so that if it goes on to appeal, you know who was there.
Is that actually enforceable? Like if they would actually perjure themselves, either intentionally or not unintentionally? Is that enforceable?
So
Or-
an unintentional perjure is probably not going to be punishable, but if they do, I mean, it would get referred out, and it's considered a criminal offense, so we could refer them out. Okay, so the next one is exhibits, and this is going to be anything that's not witness testimony. Essentially, it's any papers, it's any photos. If you get letters from someone, that's going to be an exhibit. And what you can do is that you have to admit everything into the record in order to consider it and have it be part of your entire hearing. But you can admit everything into evidence at the very beginning. So you can say, okay, what exhibits do you want to bring in? Staff will bring forth theirs. The applicant can bring forth theirs, and the opponent can bring forth theirs. And you just label them all, and you just note who they came from, whether it's staff or the opponent or whoever. And then you just mark them all like A or 1 or whatever numbering system you're going to use. It's a good idea to keep an exhibit list, just because I have seen where you're like looking after the fact going, oh my goodness, how many exhibits did we have? And you're trying to listen to the record. But as long as nobody objects to introduction of an exhibit, there's no problem with accepting it. So we're going to go on to objections next. So if somebody objects, all you want to do is repeat it into the record. And if it's opposed, which you'll just ask them, do you oppose their objection? If they do, you just want to find out why. It doesn't have to be anything really complex. You can just get their information. You'll decide on it as a commission, just like a regular vote. But if you don't feel like you have enough information, or you don't really know if it's something you can rule on yet, you can just take it under advisement, and you just have to rule on it before you actually make your final decision. So if while you're deliberating, you want to call an attorney, you want to send somebody to go, get legal counsel's advice or something, or you want to go, whatever you need to do to make it happen, that's fine. Or you can discuss this part of your deliberations. And hearsay. So hearsay is an out-of-court statement offered for the truth of the matter. Now, that matters if you're an attorney, because in court, you can't allow it. In a quasi-judicial hearing, you're not attorneys. We don't expect you to be attorneys. And so you can accept it, but the recommendation is always to corroborate it. So if somebody says, I can't provide X because, or somebody told, the applicant told me they can't do X because of Y, and here's Y to prove that they said X. That's all you need. Does that make sense?
Can you fill in those X's and Y's so we have a specific example?
I don't know. So let's say I can't, the applicant told me that they won't actually be putting in some requirement they have to because, I don't know, they have to put in a sign that because they can't afford it because they have $50,000 in medical bills. And then they present the medical bills to prove that they actually said that. Something like that. Does that work? Okay. Okay. So now that you've gotten all of the evidence that you need, you've kept everything in the record, it's actually time to take action. And so, like I said, sometimes you can deliberate in closed session. It's not common, but even if you deliberate in closed sessions, you have to make your decision in open session. And when you do it, it has to be a motion and second, and you have to do a roll call vote. And you have to state in your decision, you have to state on the record what your findings of fact were and your conclusions of law. Basically, you need to explain your whys and your hows. So we found that they, you would know this better than I do, the property isn't actually 30 feet back, it's only 27. There is insufficient area for a turnaround because the turnaround requires 80 cubic feet and there's 12. You know, you would just want to make sure that you have those actual factual determinations, and then you apply it, which is that's not possible to do this the way they said, and so we're going to deny it based on these facts. Okay, so
Excuse me. When you say that individual votes must be recorded, so you have to go down the line and state how you voted?
that is the best practice, but as long as you can tell, as long as it's evident on the record how everyone voted, that's okay too. But what we need is just to make sure that every single person's vote is recorded.
Do we need to explain why we voted the way we did?
Nope.
We can just,
Your deliberations and your explanation of the decision of the commission as a whole, that's sufficient. You just need to know who agrees with it and who doesn't.
For the record, does that mean the taped record or the minutes?
So it means both. So really what you're supposed to do is provide a written finding of facts and written conclusions of law. It's one statement just basically explaining what your decision is. However, I have read somewhere that they're getting a little more lax with that rule when it gets up on appeal to different courts. And instead what they're saying is, as long as there's somewhere written that people can go and look and see what your findings of fact and conclusions of law were, then that's sufficient. So you need your minutes to actually have that in it. But if this gets appealed, they're going to look to what the oral testimony and everything that was included, they're going to consider that as well.
Because we don't need to actually supply the written part of that.
Correct.
It's supplied by the person who's typing up the minutes.
Correct. And if we get to a point where we feel like it's to the best interest to actually be drafting up written findings and conclusions, we can figure out how to do that so that it's easier for you guys. But I think because of how long it is before you guys meet, that the best approach, and thank goodness they're doing this, is to make the minutes your written determination.
And I know, again, in the past, we had the person who types up the minutes now, that person was present at the meetings and taking minutes in writing. And I think if we're going to do something like that, that would work best rather than have one of us attempt to do that.
I agree. I agree. And it's not something, this isn't a requirement that you guys create them, it would just be that you approve them. Okay, so that's basically it. Last slide is just kind of a summary. If you're doing due process, you have to have notice and hearing, and then you need to make sure your decision is not arbitrary or unreasonable. You have to do it anytime you're dealing with a small group or your decision's affecting only a handful of people or an individual. And the purpose is just to satisfy fair, justice and fair play. So as long as you're treating people in a fair manner, giving them an opportunity to really be heard, you're going to be fine. You guys have any other questions?
A question on evidence.
Okay.
So, staff generally prepares a report, which I guess gets introduced as evidence. Can the Plan Commission members ask staff to bring certain items to the meeting or present as evidence?
Give me an example.
So let's say, maybe, so we're talking about like site visits and just instead of, plan commissioners going off and doing independent investigations, could they ask staff can you bring some aerial photos or can you bring some current photos of the house or the backyard or just, the thing that we're looking at, can you go out and take some pictures and provide that for us? Can they ask us to do that?
I think that's perfectly fine, and here's
Okay.
why. Because if you were in the hearing, you could ask staff those questions. You could ask for that information. And so I don't see any problem with it, because if you can do it during the hearing and it's going to be disclosed on the hearing and you're asking for procedural stuff, not actual stuff pertaining to I think this is this site really as ugly as it looks when I drive by it? I think that those are perfectly fine questions.
Are there areas where a plan commission makes the ultimate decision? I know almost everything that we do, if not everything, is a recommendation to the common council. Are there areas where the plan commission is the final deciding body?
We have put in a few cases, I believe, for PUDs, where they would have to come get the site plan approved by Planning Commission, and Planning Commission only. I'm just thinking we just went through one of those.
Yeah.
What project was that?
Universe Festival.
No, it wasn't festival. There was another one that came back, and it was like this ends here. Just pull back up. But that was it. Just needed to come back to us, based on what was originally put in the PUD. Was it? It was the Baskin Robbins, Grand Central Station.
Oh, yes.
Yep. Then they needed to come back to us for
It
some final
wasn't
site
just
plan
to the
approval.
planning staff, but to
Correct.
the commission.
To the
That's
commission.
right,
Yeah.
yeah.
Mhm.
See, we remember ice cream.
Everybody remembers ice cream.
So I have another question on, the hearing. Is it best for us to arrange, and I know we asked this on the slips, to arrange that process from having those who are in favor of the project speak, and then those who are against the project speak? We tend to have sometimes those who are just kind of the meddling middle, I like to call it. I'm not for or against this project, I just want to make a comment on it, or ask a question on it. How do you handle that, or do you know what I'm saying? It just in terms of the testimony, because sometimes you get some who just haven't taken a side. Do you force them to take a side, or how?
No, I don't think you need to force anybody to take a side. So if somebody is providing testimony in favor of one or the other, you would want it to be as part of that same grouping. This way, the other side, it just keeps it cleaner. So you've got
Okay.
everybody in favor going at once, and then you have everybody who's opposed going at another time. But then you've got the general health and welfare, and so if people just say, I don't really care, I just want to make sure that you consider this, there's no problem with that as
Or
well.
they might have a question. I'm concerned about such and such, and whether or not you've ascertained that the traffic won't be disrupted. That sort of thing would also be a not for or against.
Yeah, I don't see any problem with just having them go last.
But there's also on your listing the possibility of rebuttal by the applicant.
Yes, so let's say for example, so anytime you're in a court, the person with the burden of proof goes first, which is kind of what the applicant's doing. They're kind of trying to convince you that they're entitled to a CUP. So they go first. Then the other side comes and says, no, and they give all their reasons, and then because they have the burden of proof, they get to go one last time and explain why it is that this side was wrong. If you're going to give time limits, you can consider that last rebuttal. They can reserve 5 minutes. So let's say, for example, you gave each side 30 minutes. They could do 25 minutes up front. The other party does 30, and then the last one would get 5 minutes to rebut. And a lot of times they won't take all of their time, you just have to give them equal time. And so you would finish those up, and then I would say probably during the questions period is when you would have the people who are neither for nor against come up, and you can ask them questions essentially.
So for example, if it's something that's occurring specifically in one neighborhood and it really only affects that neighborhood, and somebody who lives in a different neighborhood or even outside of the city wants to come up and talk, they can.
That's up to you guys.
Okay.
If it's, what you're looking for is if it's credible, if it's relevant, and if it tends to prove or disprove. So if they're going off on a tangent about how this is terrible compared to what Hobart's doing, you're not going to care. It's irrelevant to what you guys are considering.
But we use
How do you
these
read
common requests
Say that.
to speak forms, and Mayor Beth does a good job organizing those requests to speak forms, where if someone wants to address the commission, you put your name and address and what the issue is, that kind of thing.
Yeah, usually the city planners will put that together and give it to us.
Right. Yeah.
And what's really important is that you guys do what makes this most sense for you all. This format is just a recommendation, but as long as you're giving them an opportunity to be heard in a meaningful way, that's all you need to do.
I want to ask about time limits.
Okay.
The example you just gave was 25 minutes for this side plus 5 reserved for rebuttal and 30 minutes for that side. Most frequently, when we're dealing with a CUP, we have the applicant and maybe 1 or 2 people supporting the applicant, and then 10 members of the neighborhood. Can we set the time limits by saying that each person will have up to 5 minutes, period?
You can
Or
say
does it have
that
to be
each
like
person who's going to speak will only have 5 minutes. They can only have 2 minutes. I wouldn't do less than 2 minutes, but if you got a bunch of people here and you needed to keep moving and you don't want to keep everybody here all night, there's no problem with limiting them to 2 minutes each.
But we wouldn't have to have equal time given to the proponents and the opponents.
No, as long as you're giving equal time to different types of people. So if you've got the parties, the people who are specifically affected, you could give 5 minutes to the people who would actually be, anybody who's entitled to notice. So the adjacent landowners and then the property owner himself. Or you can just do it and you each get 30 minutes. You figure out who you want to speak in that 30-minute time block.
They're each getting equal time.
And you don't have to do,
Simplest.
you don't have to do time limits. It's just if you want to do time limits, just do it.
So if it's
Equally.
only really if there are a lot of people here.
It's up to you. But yeah, I mean, if
No,
you've got a lot of
that's-
people, the time limits definitely have to keep things moving.
If there's like a full room.
Now, what about other people? For example, sometimes we'll have 5 people from city council who want to speak, and then they want to come up and speak again, and then they want to speak again on the same topic.
This, I mean, it's going to be the same thing. Because this is a quasi-judicial hearing, it's going to trump any legislative rights they would have. So the applicant's entitlement to due process is going to trump that.
So they would have the same amount of time as somebody else, and the same quantity. number
And they
of
would
times.
also be speaking either for or against in that grouping.
Yes.
Okay. What if, sorry.
When we get to the question stage, though, can we ask questions of anybody who has spoken?
Yep, you're entitled to ask any
So we
questions you
ask
want,
them to come forward.
as
here.
long as they're relevant,
Credible.
and
Right.
tends to prove or disprove. Because
Yes.
you don't want to get off into some crazy tangents, because that's when it looks like, oh, they're biased against something, or they've got a conflict and they're just trying to help this guy out or something.
But we could ask them as they're speaking.
But we could also ask them to come up afterwards.
Yeah, if you have
When we're
continuing
deliberating.
questions.
Yeah, if a question comes up during the deliberation.
And your questions are independent of any time limits. So you can ask for however long you want. You're the ones who are trying to find out that information. But as far as them just deciding to give you information, you can put a strict time limit on it.
Got it.
Now, what if there's an ice cream shop that comes through here, and then they open up, and then they invite us to come and enjoy ice cream at their ribbon cutting? Can we do that, or is that considered a meeting?
So you would probably want to notice the potential for a quorum.
Right. I mean, if it's a formal invitation to the planning commission as a whole, I think it would be best, just any time that you think that there may be a quorum, like if you get a notification for that, just to notice. I mean, same thing I think goes for city council, when they get asked or be, just notice like, look, there may be a quorum present here, no action is going to be taking place.
Yeah,
It's better to err on the side of noticing it rather than somebody goes and like, all right, 4 planning commission members are there, like, oh,
So,
conveniently or here.
Nobody will
Tim
ever
just mentioned
complain.
the tall ships, for example, when there was a, what was that, an invitation from the mayor, right?
Yes.
To the tall ships, do we do a notice then?
I think, yeah, last year, like when we invited, the mayor invited all the members of the boards and commissions. I think everyone was noticed, like, there may be a quorum of all these groups present, no action's being taken.
Okay. Now, what about when the mayor does the state of the city?
City, yeah, same thing.
I think I saw a notice of
We always
quorums.
avoid having a majority of the council together as a group discussing something.
Yeah.
You know,
Yeah.
if you stay apart, you're less likely to have a problem.
We all
And,
stay in your little clips.
yeah.
That's all self-policing, is what it really comes down to, you know.
You will never have people complain that you gave too much notice. They only complain when you don't give enough. So erring on the side of notice and due process is always favorable. You guys have any further questions for me?
Nothing wrong with the ice cream either.
It makes people happy.
You get bread by ice cream and water.
That actually did happen once.
Man, watch me, sprinkles, man, we had all kinds of good stuff.
Oh,
Cookies.
yeah, that was one of my early meetings. I thought.
Well, thank you, Vanessa. And I think based on this, we'll talk and, maybe have a few small tweaks just to our next agenda in terms of how we're setting things up, or maybe if there's small things that we need to tweak a little bit, just in terms of making sure, as we go through, these hearings, that we're, going through the process. And I think, Vanessa said, it's just, I don't want to get so caught up in the intricacies of every little thing. Just focus on, at the end of the day, that we're providing that due process and when needed, erring on the side of caution that, again, you can't have too much process or make sure you fulfill that opportunity. All right. Well, thank you for coming in.
Welcome.
With that, I guess,
Thank you.
share your pleasure how you want to continue the meeting.
Do we have a motion to adjourn?
Second.
Got a motion and a second to adjourn. All in favor?
Aye.
Opposed? I think I heard everyone say aye.
Oh, yeah.
We could
Let me give these to,
Thank you. This was very helpful.
let me give a bunch of stuff.
Cheryl,
Cheryl, I'm gonna be calling you tomorrow.
That's a.
You were on my to-call list today and I spaced it.
Can you forgot